Welcome back to Law and Crime's afternoon session. My name is Bob Bianchi. Today there was a hearing involving OnlyFans model Courtney Clenney. She was arrested in August and charged with second-degree murder in the death of her boyfriend. Clenney said she threw a knife at him in self-defense, but prosecutors say the trajectory of the knife was a downward stroke that couldn't happen from a 10-foot throw, as Clenney had indicated occurred. There is also an elevator video that shows that she could be the possible aggressor in the relationship. Clenney's trial is expected to start on December 19th. Today, the defense asked for a protective order to limit what discovery made to the public can be available, which was opposed by the state's attorney's office and the Miami Herald. In other words, the defense saying too much information is getting out there, and the prosecutor's office and the Miami Herald saying, no, we don't think we should be limited. Defense attorney Frank Prieto ended his argument before the motion was denied. Let's take a listen.
We want this to be orderly. Judge, the release of sexually explicit videos, audios, personal information exchanged between Ms. Clenney, her family, this background noise that we're trying to prevent is why we're here. And, you know, Judge, the state's talking, I washed my hands this morning. They're not unclean. They're clean. They've been clean. To vigorously defend my client, I'm not going to stand back and let her be a punching bag in the media. So any contact that I've had with media outlets has been to push back against a false narrative that's being put out there. And that's well within our right, which is actually why we're here, because then we can craft a protective order that not only keeps the state in check as being a minister of justice as they should be, it prevents the defense from doing the same thing, which I'm happy to do. Something needs to be put in place, Judge, to guarantee my client's right, but also the orderly administration of justice in this courtroom. Judge, I received, just to talk about the impact of releasing these drips of discovery, I received somebody on August 14th was so impacted by the release of this video that they felt the need to go to my website and click on the ability to send me an email. And it says, sorry, bud, but Courtney is going away for murder. After seeing the earlier video of that elevator, there's no way her self-defense story holds up. She's a psycho that needs to be locked up. This is not the only one, but this is the intention that this garnered. Somebody felt the need to go and communicate with me directly because of this video. And there is no way that the state or the defense can tell you exactly where all these clips come from. What we know, the volume is extraordinary. Millions, millions and millions, which in order to protect the fair administration of justice under the rules of judicial administration, when looking at future voir dire, I think a protective order is appropriate. Thank you.
Thank you. Thank you both. Anything further from either side?
Nothing from the state, Judge.
Not by the defense, Your Honor.
Thank you.
All right, Mike, the judge immediately denied that motion. Now, again, each state law is different. The judge cited state law as to why it would be admissible, kind of indicating that state would allow this kind of thing. And I go to where our state in New Jersey and how paranoid I was as the county prosecutor. I precipitated a class that had to be given because there was an order that said you have to inform the public as to the nature of the charges, the status of an investigation, whatever, but you are not to present anything by way of any evidence to the public unless it comes through a court filing or in the courtroom itself. It's called an extrajudicial statement. And prosecutors have been sued for making extrajudicial statements. They've lost their licenses to practice law for making extrajudicial statements, because what it can do is affect the administration of justice when information is being brought out by a prosecutor in particular. That could have a very harming effect, as this lawyer also said, on your voir dire, the potential jury pool. So while the state laws may differ here, I have to be honest with you, my prosecutorial instinct even tells me this is something I would not be leaking, when I say leaking, giving to the public, unless it was through an actual court filing and then the media got it on their own.
Well, that's an excellent point to bring out. I think that actually is probably one of the best safeguards for this, because what it does then is it's a filing, it's put in with a purpose and it's relevant to the case. Now, this video they released earlier, I don't know if one of the reasons they may have released it is no different than saying to the public if they on a person who's wanted. They put the picture in the video. Does anybody know this person? Has anybody seen him? At the time, they're not necessarily a defendant. They may just be a suspect, and they're starting to collect
Fair enough, but I don't
evidence.
think that's what happened here.
I don't either.
Right, so they're just brief. And what if that evidence is not admissible and everybody is seeing it because it's a prior bad act and I've got a short period of time? I mean, this is something that I just think is just not acceptable in my mind.
Well, the defense better hone in on the voir dire for the jury as to this so they can preserve an appeal that may overturn a conviction if it comes.
Okay. All right, excellent. Mike Koribanics.